Welcome to the latest episode of Call to the Bar, International Law Over Drinks. I'm your host, Tamsin Phillipa Paige, Associate Professor at Deakin Law School. Today I'm joined by Douglas Guilfoyle, Professor of International Law and Security at UNSW Canberra, to discuss the recent Israeli Defence Force interception of the Freedom Flotilla vessel Madleen, a British-flagged yacht attempting to carry aid to Gaza with a crew including Greta Thunberg. We'll cover questions including the law of blockade, the war crime of starvation, and as we tap the sign, why this isn't piracy or hijacking. But before we begin, I remind everyone that these informal conversations, we are speaking, as always, off the cuff and without the benefit of footnotes, and nothing we say should be taken to have been thoroughly peer-reviewed. But before we get down to business, Douglas, what's your drink?
So we've actually recorded 2 episodes in the one day, and I've forgotten to change my drink between. So I am still on Korean hydrangea tea, the reason for which will become more apparent to people in a later episode.
I, however, have remembered to change my drink, and I've went off and made myself, now that we're getting into early evening because winter and the sun's going down, a hot chocolate, just using the Grounded Pleasures original hot chocolate powder, and it's delicious and warm. And it's basically like a hug for your taste buds.
Ah.
So, on to the main event. Let's deal with some background first. Douglas, what the fuck is going on?
Okay, so yesterday it was reported, so this was on the 9th of June 2025, that an aid vessel carrying a number of activists and celebrities had attempted to breach Israel's maritime blockade of the Gaza Strip and was carrying some humanitarian supplies, not on an admittedly particularly large vessel. And one of these passengers was Greta Thunberg. As we've said, the vessel, the Madleen, was flagged to the United Kingdom. We can come back to whether that's of any particular significance. And then it was interdicted by the Israeli Defence Force, the IDF. So there were reports that it was its communications were jammed, that it was surrounded by quadcopters that sprayed an irritant, which is an intriguing boarding technique. And then the vessel and those on board were effectively taken into IDF custody and moved into the port of Ashdod. The last I heard, they were going to be charged with having illegally entered Israel, which is an intriguing charge when you've been brought into a country by its military. But it sounds like they're just going to be deported as at sort of 20 odd minutes ago, according to a quick scan of the news. So that's the situation we're in.
And just to be clear, the interdiction occurred on the high seas, did it not?
Right. Well, so there's been some debate about this. So the Freedom Flotilla Coalition, which is the organization that sponsored this voyage, has said that they were intercepted in international waters, which, as you and I both know, is an imprecise term, but is usually meant to be a synonym for the high seas. So Israel has claimed since, I believe, the 1990s and the Oslo Accords that it has jurisdiction over Palestinian territorial waters and it will control what activities happen in there. But that obviously wouldn't provide you any basis for an interception on the high seas. So the only grounds would be, as we're going to come to, a maritime blockade, which Israel has maintained against the Gaza Strip since 2009.
Yeah, I think it's important to note that because, as you said, they've only entered Israeli territory while being brought in under armed guard by the Israeli Defense Force. So it's a particularly interesting quirk of charge. All right. So,
well, it doesn't appear that they're actually going to be charged with anything. It appears they're just going to be deported, which, anyway.
So let's get started then on the legal implications. Tell me about the law of blockade and this blockade that the IDF has over Gaza.
Right. So, I mean, at its simplest, blockade is a tool of economic warfare. If you're engaged in an international armed conflict, you have the right to prevent contraband and warfighting material reaching the enemy by sea. So that's it at its simplest. And so you can enforce a blockade against neutral vessels, vessels flying under a flag of a non-party to the conflict and say, in effect, you are bound to a port we have blockaded. We may stop and search you for contraband or divert you to another port. And if you resist stop and search measures, you may be subject to capture. So this is an ordinary part of the law of international armed conflict. But as you and I well know, it's part of the law of naval warfare, which is a difficult area because, for example, when we talk about the law of armed conflict on land, after the Second World War, everyone went, well, that was a humanitarian catastrophe. We need to codify the rules better. And we have the 4 Geneva Conventions of 1958, and then the 2 additional protocols of 1977, which have plenty of gaps and indeterminacies and things lawyers will argue about, but do give us a big body of written law to fall back on. Now, while one of those conventions does deal with protections for shipwrecked persons, it doesn't codify the general law of naval warfare. So what tends to happen when scholars debate what is legal as a matter of naval warfare, they start looking at a bunch of very old treaties, military manuals, and state practice, much of which predates the United Nations and the Geneva Conventions. So it's a particularly difficult body of law to work with.
Okay, so before we move on to our next question, I have a follow-up question on that. If blockade is a part of international armed conflict, does that amount to a tacit acceptance of Palestinian statehood by Israel?
Okay, so yeah, that's a really good question. And it goes to one of the tricky points of blockade law. So in the US Civil War, it was found by the United States Supreme Court, I can't recall the case immediately, that those who fought in the Civil War on the Confederate side couldn't be charged with treason or as pirates, if they're in the Confederate Navy, because blockading southern ports was an act that recognized the belligerency of the South. Now, that's obviously the pre-modern law, but the argument can be made that if you blockade a party, you acknowledge that they have achieved a certain status. Now, one of the difficulties for Israel in invoking blockade, which we'll probably come to, is that, as I understand it, and I'm not aware that anything has changed recently, but listeners can correct me, Israel's long-standing position is that it does not characterize its conflict with Hamas as either international or non-international armed conflict. Probably because if it were to say we're fighting Hamas in an international armed conflict, that would de facto potentially recognize Palestine as a state. Also, maintaining a degree of strategic ambiguity means you, for example, don't have to give Hamas fighters full prisoner of war status under the Geneva Conventions if you say they're actors in a non-international armed conflict. But at the same time, if you've maintained ambiguity, you can invoke doctrines like blockade, which are only clearly available in international armed conflict. So a degree of strategic ambiguity may lead to a pick and mix or sui generis approach to the law.
Okay, so given that, does Israel even have a legal right to blockade the Gaza Strip?
Okay, well, in my view, that turns on 2 questions. So as with most complicated questions about the law of armed conflict, it starts with the binary choice of do you classify the conflict as an international armed conflict or a non-international armed conflict? And the majority of the international community treats the conflict between Israel and the Palestinian territories, or more precisely Hamas within the Palestinian territories, as an international armed conflict. Now, there are various reasons for that, which I've never found particularly convincing. The usual one being the idea that Israel has never completely not occupied the Gaza Strip. It's obviously maintained occupation of the West Bank Palestinian territories, but it, quote unquote, disengaged from Gaza and kind of laid siege to it. And the Israeli position has always been, well, we're not the occupying power, we've just surrounded a hostile entity. But the kind of shorthand logic being, well, if you are the occupying power, then that's governed by Geneva Convention 4, which is part of the law of international armed conflict. Therefore, anything that happens in that territory must be an international armed conflict. Now, the reason I've never found that terribly convincing is obviously an occupying power could wind up engaging with a non-state actor like resistance movements and the like. And I think that's an open question. If you're not engaging government forces, then shouldn't that be the law of non-international armed conflict? An armed conflict is a conflict between states. If the party on the other side isn't a state, then how are you governed by the law of international armed conflict in relation to them? So this leads to sort of the complex question of, yes, but you've invaded another state's territory. Again, sidebar that Israel doesn't recognize Palestine as a state, and see all our previous episodes on that question. But for example, taking a different factual scenario, Israel pursuing Hezbollah into Lebanon, I would say you have a non-international armed conflict between the IDF and Hezbollah because the party on the other side is not a state, but also by the act of invading Lebanese territory, then the IDF has responsibilities under the law of international armed conflict to the civilian population. So that theory is called parallelism, that you can be governed by two bodies of law in the same space at the same time, and it's not necessarily the most mainstream position. Okay, doing my whole thing of rowing back to the beginning. So you've got a complex question of whether you classify the conflict as an international armed conflict or a non-international armed conflict. If you take the majority international community position, it's an international armed conflict, then prima facie, Israel has a right of blockade unless something else makes it illegal. If you take the view that because their enemy is Hamas, and Hamas is a non-state actor and it's a non-international armed conflict, then you have to prove separately that blockade is available in a non-international armed conflict. And what I'd say about that is the state practice is very, very patchy. You've got the US Civil War, you've got French operations off Algeria during the Algerian Civil War, where they didn't invoke blockade. Again, for your point, Tamsin, it would have conferred recognition on the Algerian forces. And you've maybe got events in the course of the Sri Lankan Civil War which are contested. Like, there is not a lot of state practice. So the fastest route is, if you generally think that this is an international armed conflict, then prima facie there's a right. If it's a non-international armed conflict, you've got a harder question to answer.
So following up on that, would this be functionally akin to your discussion around Hezbollah and Lebanon, in the fact that we've got pretty broad consensus of Palestinian statehood globally, but treating Hamas as a non-state actor within that Palestinian state,
Yep.
which then provides obligations as occupiers, noting that the recent advisory opinion did acknowledge continued occupation of Gaza, even though Israel denies that, to the civilian population, but different engagement rules under a non-international armed conflict with Hamas. Is that an accurate assessment?
I think that's an accurate summary of how I'd approach these things. And it doesn't give you a clear-cut answer on the role of blockade. Because you could still say, well, at the end of the day, we're in an armed conflict with an adversary. We have a right, whether it's a NIAC or an IAC, to deny supplies getting to our adversary. One of those tools is blockade. So I guess short version, definitely available in international armed conflict, maybe available in non-international armed conflict. There's a question of characterization there, and how you characterize the conflict in Gaza is is an analytical question you've got to make. The bottom line is, though, on any theory, the protective provisions of the law of international armed conflict, I would say, apply to the civilian population. So I'd like to get that out there, right? If Palestine is a state and Israel invades the state, then it owes duties to the civilian population.
Fantastic. So when does a blockade become unlawful, and why is that a controversial question in naval warfare?
Right. Yes, good point. Sorry. And just to modify my previous answer, because this is such a thorny area, I think Israel obviously in general has a right to self-defense. That right just has to be exercised within the limits of the law. All right. So when does blockade become unlawful? So the thing is, as I said, because the international law around the law of naval warfare is so messy, right? We don't have a single modern treaty that pulls it all together. There have been different efforts at codification. And as we've said in previous episodes, codification is, indeed in our piracy episode, the idea of codification is you take messy, unwritten law and try and reduce it to writing to gain more consensus and certainty. So when you don't have codification in treaties, sometimes what you have is codification in expert manuals. So experts will sit down and hope to influence the development of the course of the law by saying, we've surveyed the materials and we reckon this is the rule. So a big push in this direction was the 1994 San Remo Manual on Naval Warfare. Again, not a government manual. It's sometimes associated with the Red Cross. Actually, it was produced by an Institute of Humanitarian Law. It took the view that you need to read the historic law of blockade in light of those subsequent developments we were talking about, including in Additional Protocol 1 to the Geneva Conventions, the prohibition on starvation as a means of warfare. So in its treatment of the law of blockade in rule, I think it's 102 or 105, the San Remo Manual says a blockade becomes unlawful or will be unlawful if it has a disproportionate effect on the civilian population compared to the military advantage that is foreseen. Now, that sounds like the ordinary principle of proportionality, right? That sounds like a fair enough thing to say. If you're, crudely put, starving more civilians than you're gaining military advantage, maybe you shouldn't be in the business of blockade. However, a different expert manual, which was led out of the US Naval Academy, Naval War College, came to a different conclusion. Now, this was written by an international group of experts, including our friend and colleague, Professor Rob McLaughlin, so it wasn't a purely American effort, came to a different conclusion. And the Newport Manual said, look, all we're going to do is try and come up with an authoritative statement of the law as it is with reference to historical sources. Now, that's a worthy project, right? Because you get clarity by trying to just distill the lex lata. The problem that you potentially face is, as we were just discussing, the general principles of the law of armed conflict have moved on since 1945. And if you only codify the pre-1945 law, it may not strike the balance correctly. But they come to the view, fair enough on its face, that there is literally no state practice, no treaty law, and little in government manuals that supports the San Remo position, which is putting that starvation principle and a proportionality principle onto the regular law of blockade. So they say in the Newport Manual, in I think it's chapter 7, a blockade will be illegal if its sole or primary purpose is the starvation of the civilian population. But you don't apply the proportionality test to a blockade because a blockade is not an attack, right? A blockade is not like firing munitions onto land from the sea. A blockade does not have a direct kinetic impact. It's therefore not an attack. We therefore don't have to apply the proportionality test to it. Tamsin, I'd love your reaction on that.
I do believe my reaction is get fucked, and that's somewhat archaic. We know from lots of different things that secondary effects factor into proportionality questions. We also know from looking at cyber warfare that scale and effects tests still apply, and that's a non-kinetic attack.
Right, right. So I think that second point is really important, right? Because lots of states are increasingly saying that we will treat as an armed attack a cyber attack of sufficient scale and effects, even if it doesn't directly cause death and injury. And if that is true of a cyber attack, it is then true of everything that has major non-kinetic consequences.
Non-kinetic consequences, and particularly on the civilian population. And noting, we've made that argument with Rob McLaughlin, where he has agreed with that position that cyber infrastructure disabling because of the second order effects on the civilian populace is subjected to a proportionality test. So I actually think that the Newport Manual got it wrong there by ignoring the general principles of IHL that have developed since the law of blockade kind of
Right.
became settled.
Right. So if we take this, the bottom line is, if we take the kind of, to oversimplify a bit, if we take the Newport Manual approach, a kind of old, strict view of the law that doesn't take into account these other considerations, then a blockade is only illegal if its sole or primary purpose is starvation. If it has a legitimate purpose and unfortunate incidental side effects, that's bad. There might be other branches of the law that address it, but it's not an issue. If we take the more progressive San Remo manual approach, the blockade becomes illegal once it starts to have disproportionate civilian effects.
Yeah. So it's clearly not settled, but it sounds like you and I may be of the view that this is not necessarily a lawful blockade, which gets us to the point we have here, which is the humanitarian crisis in Gaza beyond the continued, I would say, disproportionate attacks on civilian populations. The accusations, there are also accusations that Israel is committing genocide being heard before the ICJ. But the important one here, which you've already kind of raised, is the war crime of starvation. So, why is this the important feature when engaging with this question of the blockade? And what is the evidence that would support finding that deliberate starvation of the civilian population is occurring in Gaza?
Okay, right. So there are a couple of different questions here. So my view would be, if the blockade becomes part of the same pattern of conduct as a separate crime of starvation, then regardless of how we resolve the dispute between the San Remo manual and the Newport manual, it's illegal, right? It's tainted by the illegality of the other crime. Now, I don't have a particular case or authority I can point to that. It just seems to me to follow as a matter of logic. Like the blockade must fall as an illegality if it is being done to support the crime of starvation. Now, starvation is a war crime. Starvation involves not just the deprivation of food or that people actually literally die of lack of food, but also depriving the civilian population of their means of survival. So things like the destruction of shelter, of medical facilities, etc., in my view, could fall within, and the denial of medical supplies could also fall within a broader conception of the definition of starvation. Now that infliction of conditions capable of bringing about the destruction of a population's life could also be a means of committing genocide. But the problem with genocide is you've got an additional intent requirement. You have to prove that this is aimed at destroying the group in whole or in part as such. To prove starvation on very similar facts, what you need to prove is the intent to use starvation against the civilian population as a weapon of war. And the thing that we've got there is a declared policy of starvation by the government of Israel since at least the 2nd of March 2025. Now, I think there's evidence from which one can infer a policy before that, but I got a lot of pushback, particularly from lawyers with a military background in the US saying, no, 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 there's a very strict intent requirement for the crime of starvation. Well, on 2 March 2025, the Prime Minister of Israel on Twitter accused Hamas of walking away from talks and as a consequence halted, and I quote, entry of all goods and supplies to the Gaza Strip, end quote, and warned that unless all hostages were returned, open quote, there would be additional consequences. Now, on its face, I think that is a confession to the mens rea of starvation. You've said to achieve a military objective, we are going to halt the entry of all goods and supplies. I don't see that's open to a second interpretation, and that situation persisted for over 10 weeks. So at an absolute minimum, on the strictest possible interpretation of the crime of starvation, you've got evidence of mens rea there over 10 weeks. And I would say that position has not been walked back since. We've seen a resumption of aid, but to a level that the Red Cross has described as not meeting international humanitarian standards. And the Israeli Finance Minister, Mr. Smotrich, has said that their only intention is to do the bare minimum to avoid being accused of war crimes. So to me, that doesn't signal a good faith change in policy. So I'd say one could infer from that the mens rea of starvation continues. And if there is a general crime of starvation unfolding in Gaza, then the actions that support that crime are also illegal, such as enforcing the blockade.
Yeah, so which would even satisfy the Newport Manual interpretation because at that point in time, the primary purpose of the blockade, prima facie, is the crime of starvation. Yes?
Look, I hadn't actually thought of it in those terms, but yeah, if the point of denying all goods is to inflict collective punishment in order to bring your military adversary back to the bargaining table, then you're right. That would seem to make out the elements of the offence.
Which would also be a violation of the obligations under law of occupation in the Geneva Conventions. Yes?
Yeah, I mean, so look, I'm not an expert in humanitarian aid distribution, but obviously that the occupying power, and this goes to blockade as well, right? The occupying power isn't required to allow aid in willy-nilly. Like they are granted a degree of control because it is a legitimate concern that, for example, food supplies could be diverted to enemy forces and not reach the intended civilians. But, you've got to allow entry, you've got to allow passage, and you've got to allow distribution. And I don't think Israel's actions at the moment meet those standards or meet them meaningfully.
On the face of it, on the basis of this discussion, it's I see very little to support the legality of the continuing blockade. Is that a fair assessment?
Yes. Look, if sufficient aid were arriving by other means and the blockade was just there to prevent weapon shipments entering the territory, then, and you accept that it's an international armed conflict, then that would be fine. But that's not the situation we face. Okay, so look, turning the tables. Tamsin, do you want to tap the sign and explain why this isn't piracy or a state-sponsored violation of the Sewer Convention?
Yeah, so this came up because there was at least circulating around on Blue Sky the suggestion that we should treat this incident as piracy. The boarding by the IDF of the yacht and the diversion to an Israeli port, etc., should be treated as piracy. And there are so many reasons why this is just a bad idea, which goes back to our previous episode on how people actually don't understand the law of piracy. Just because something happens on the high seas doesn't make it piracy. And the reason for this is actually really simple. It must be a private vessel engaging in the violence, and it's a warship.
Yeah,
It's a warship. It literally, unless the Israeli government is accusing everyone on that warship of engaging in mutiny and
right.
no longer being a government vessel, but a mutinous pirate vessel, which they're then going to have to arrest all of their people that brought these activists
Right, right,
and the
right.
yacht back.
And I mean, just to underscore that point, like the one exception in the UN Convention on the Law of the Sea when a government vessel can commit piracy is when it has mutinied and the crew is acting for their own ends, right?
Yeah, yeah, and they're clearly not. Even if they had mutinied, they're still clearly acting in accordance with the Israeli policy, given the statements we've seen from Israel. So that even any claims that there's been mutiny are just bogus.
Right.
So
Well,
there's
but
been
and no, and again to underscore it, no one serious is making that claim,
no
right?
one's making that. I've not seen anyone make a claim that there was a mutiny and this was an act of independent uh, naval personnel
Right.
outside of chain of command. There's no suggestion of that. So it can't be piracy. It just
So,
straight up
so,
can't be.
so
But this
tapping the sign,
matters.
boys and girls, governments don't commit piracy.
And
When they
and
do bad stuff at sea we don't like, that still doesn't make it piracy.
and that's really important because the minute it becomes piracy, there is no state responsibility.
Right.
And that matters because
Right.
and if we want to see why that matters in terms of flag state responsibility for incidences at sea, ship to ship, for overzealous activities of navies outside of their legal authority, the MV Saiga number 2 case
Right.
demonstrates why it's important that we can still tie this to the state and state responsibility for compensation issues, etc.
Right. So just to sum that up for anyone who's not followed the point, where a government does a bad thing and you want compensation, the legal link is called state responsibility. And the core of that is the entity that's done the bad thing is a government entity. But the moment we say something is piracy, we're effectively saying the crew has mutinied. They are no longer under government control. This is also a question of individual criminal responsibility because it's the crime of piracy. And that would appear to sever the link to government control. Whereas if you have a warship that does things outside the scope of its legal authority or orders, it's still doing it, as it were, under the colour of the authority and power given to it by the state, and you would still have state responsibility. So as you say, if you brand this piracy, if you come to a legal conclusion it's piracy, you can no longer hold the government here, Israel, responsible for what's happened, which I suspect is probably kind of important to a number of people involved in these efforts.
Exactly. So, like, let's not lose our minds and call bad things by states at sea piracy. Piracy is a very discrete crime
Right.
that requires people not to be state actors.
Okay, so let me hit you with my other question. So the other thing is, I had my phone ping before I even knew this was happening with a question from a human rights lawyer, which was, can I call this hijacking? And I'm like, well, hijacking at sea we would normally consider is governed by the Suppression of Unlawful Acts Against the Safety of Navigation Convention, which we discussed in a previous episode. Tamsin, what's your read? Can states commit a violation of the Sewer Convention?
No. And they cannot because of Article 2.1a, which says
that's as far as you have to read, people. You only have to get to Article 2.1a, like you're still on the first page.
This convention does not apply to a warship.
Right.
Straight up doesn't apply again because it would sever state responsibility.
Yep.
And this is the key here.
And for anyone who wants to make an argument, it doesn't apply to a warship, but maybe it could still be committed by a warship, then you only have to read down to Article 2.2. Nothing in this convention affects the immunities of warships and other government ships operated for non-commercial purposes.
Yeah, but the point here is you don't want it to be treated as these things because you want to be able to hold a state responsible for the actions of their navy. You actually want that. Because then you can go to ITLOS and say, you caused by actions of your navy damages to our flagged vessel, and we are taking an action against you in the International Tribunal Law of the Sea. And here is the evidence. Here is the wrongdoing. We would like compensation, etc. Because UNCLOS provides mechanisms for compensation for unjust and invalid exercises of the right of visit and interference with other vessels. And you want to be able to use that tool. You don't want to sever that tool out of a fit of pique over what a state's navy has done. And if you're still concerned, well, we can't hold the individual sailors responsible, you can, because it can still fall under various war crimes with individual responsibility. You can have both if you don't call it piracy or a hijacking under the Sewer Convention.
Right. So something I've only just thought of in real time, which I won't fully flesh out here, but as you've said, one of the mechanisms that a flag state could use to seek compensation for a vessel unjustly detained on the high seas is proceedings before the International Tribunal for the Law of the Sea. There is prima facie an exception for military activities in UN Convention on the Law of the Sea dispute resolution. So one might attempt to run the argument that military activities that aren't actually justified by the law of naval warfare aren't covered by that exception. I suspect that wouldn't fly, but the width of the military activities exception and alternatively the law enforcement exception in UNCLOS are open to debate, are to some extent contested, and you could still, regardless, you could still seek provisional measures. So if Thunberg and the crew aren't released quickly, you can still go to ITLOS and say, pending a dispute and pending resolution of this jurisdictional issue, you've got to let these people go. So you could still, wouldn't technically be prompt release because that would be about, I think that's technically restricted to fishing vessels. But you could still seek provisional orders of release as a provisional measure. So the analogy there would be the Arctic sunrise case.
Yes, sorry, that's the thing. But and this is where it would hinge on how the military activities and law enforcement activities got interpreted in light of the MV Saiga number 2, which was found to be an invalid exercise of those authorities and therefore
Yeah.
liable to the ITLOS jurisdiction
Well, and the
for
other thing I'd say is Russia in the 3 Ukrainian naval vessels case said, look, ITLOS, you plainly have no jurisdiction to even order provisional measures because this was obviously an encounter between naval vessels. And ITLOS went, it seems kind of uncertain about whether this was really a military activity. And that's enough for us to order provisional measures, even if we might come back in a full case and go, you're right, there's no jurisdiction. So there's sort of a loophole there where you can get orders from ITLOS based on a very preliminary evaluation of the evidence that might not fly at a full hearing.
exactly. And so you don't want to sever that relationship of state responsibility because it cuts off avenues and tools of legal recourse. And why would you do that? And the other relevant case that you need to look at as to whether or not that would apply would be the Enrica Lexi case, where you had all sorts of questions over who had jurisdiction over the Italian Marines who shot some Indian fishermen thinking they were
Mistaking them
pirates,
for pirates. Yeah.
mistaking them for pirates, and that's a whole saga that we don't have time to get into here. But the point is that state responsibility is your friend here, and you don't want to sever it by going, oh, but they're pirates. Um, yeah, states don't commit piracy, and you don't want them to be committing piracy because then you lose avenues to hold them accountable. So let's not go there. So on this one, I've got a recommendation on a book, but Douglas, do you have any recommendations to regarding
Yeah,
the
well, look, rather self-servingly, I've got a recommendation of my own. So this is not the first time Israel has intercepted an aid flotilla for Gaza. Now, obviously, Israel has said this was a very small vessel, and we think this was more of a publicity stunt by celebrities than a genuine effort to deliver aid. I don't think that actually matters if you're attempting to deliver aid. I'm not sure the quantum really is an issue, but certainly there was a much bigger incident in 2010 where the Turkish ship MV Mavi Marmara, as part of a flotilla, was going to attempt to deliver, significant quantities of aid into Gaza. And when the IDF intercepted that vessel, 9 activists were killed. There were confrontations. Some of the protesters on the vessel apparently took up iron bars, but it was later found that not all of the shootings by the IDF were consistent with self-defense. Self-defense claims, obviously, if someone is shot in the back, they're not posing an immediate threat. But that episode resulted in a lot of diplomatic fallout for Israel, and no less than 1 Israeli and 2 UN inquiries, all of which found different things. But this question of when can you impose a blockade? What is it valid to do in the course of the blockade? How do we classify the conflict in Gaza? I addressed in a 2010 article called The Mavi Marmara Incident and Blockade in Armed Conflict with the British Yearbook of International Law. And atypically for the British Yearbook, it's been included in an open access. I would say I don't agree with all of the things I said in 2010, 15 years later. At that time in 2010, I was on the fence about Palestine's statehood. I'm now not. And as we've discussed in previous episodes, that is down to the overwhelming recognition of Palestine as a state by the international community. But other than that, I think it stands up. It takes the San Remo manual as authoritative. And again, as we've explained here, the Newport manual takes a different approach. But with those qualifiers, it's still a piece I'd recommend to people. Tamsin, what would you recommend?
I'd recommend a book by Phil Drew, who is a colleague and friend of mine, and he wrote a book entitled The Law of Maritime Blockade. It was published in late 2017. It's with Oxford University Press, and while he's coming at this as a former Canadian Armed Forces lawyer, his scholarship, I think, is generally fairly measured and
Yep.
precise, but very doctrinal.
Yeah, look, and it's a slim book, and it takes a straight down the line approach to the law. And some guy called Guilfoyle wrote a broadly positive review of it at some point, I recall.
Yeah, so that would be my recommendation. Or if you're interested in the law of blockade, Phil Drew has done some good work on that. So, in wrapping up, we usually ask a non-international law question, and this season we're asking, who is your favorite obscure or underrated character in fiction, and why did they speak to you, Douglas?
Okay, so look, so the question we've been asking is who is one of your favorite obscure or underrated characters in fiction? So anyone who's taken even a passing interest in my dress sense on social media could probably deduce that I'm a fan of Doctor Who. Now, Doctor Who is by no means an obscure or underrated character, but there have been a lot of Doctors Who over time, not all of whom have had equal attention. And probably one of the most underrated is Paul McGann, whose appearances as the Doctor were constrained to a failed effort to reboot the franchise in the early 1990s with the rather poorly titled Doctor Who the Movie. And then later, when the series was rebooted in the early 2000s, the BBC made two 6-minute webisodes giving some backstory that bridged from the time of Paul McGann's Eighth Doctor to the events of the Time War. And I'm getting there. I promise I'm getting there. McGann's Eighth Doctor in the Time War is just such a fabulous, in this short period of time we get to know him, this compassionate, tortured hero who's trying to do the right thing and realizes that it's time to give up being the Doctor because he can't be the Doctor this time and this place needs, which I think I find attractive in a character, in a way, acknowledging your limitations when it's time to give someone else the reins, even if it's a different version of yourself. But also, as someone who has taken up sewing in the last 3 months, his costume in that reboot moment is amazing. He has a long green velvet frock coat, a brocade waistcoat, a scruffy open shirt because he's seen the front lines of action, and a kind of ragged blue neckerchief. It's an amazing look. And the long arc of my sewing is I want to kind of produce a version of that costume for myself. I've never really done cosplay before, but there's something about that vibe that speaks very much to me. Also, the original Doctor Who, the movie, was kind of steampunk before steampunk was really a thing. And it had elements that really bridged between the classic series and the new series. So there's something in that as well.
You know I love a bit of steampunk. It's my jam.
Yeah, but the movie does also have some rather unfortunate 90s tendencies, including casual off-screen femicide. So I'm not sure I can recommend it in good conscience, but there are elements of it that are great.
I'm not a Doctor Who fan. Every time someone's tried to get me to watch it, I've walked away feeling kind of uninspired and cold, going, "Well, it's fine, but it's not for me." So that's fine too. But I do love a good bit of steampunk. But finally, Douglas, what are you wearing?
Today I am wearing an outfit I think I've described before. It's a waistcoat and trousers in brown and blue check wool that I ordered from the UK and had made up by my local tailor. A white shirt, a paisley tie with a blue background, some brown brogues with blue laces, but also I've been wearing recently a green tweed jacket that was originally my father's in the late 70s, early 80s, and that I wore for a while as an undergraduate, but I've pulled it out of storage and had it altered to fit me properly. So yeah, maybe something of a sort of a Matt Smith 11th Doctor adjacent vibe in my present office wear.
Fantastic. Well, that is all we have time for in this episode, and we'll see you all next time. Bye bye.
Bye bye. Thanks for listening.